As you can see, we have a huge panel, so you will get a variety of thoughts, comments, and don't be shy. These people are all friendly. They have been pre-vetted to be friendly. So for those of you who are students and have questions about, advocacy tips, career choices, this is a good panel to talk to. But we'll start with the issues at hand, and then we'll sort of see where it goes. Alyssa, over to you.
Hello, welcome, bienvenue. So I think the first thing we'll do is start by having everybody introduce themselves. And the first thing we'll do is just name and who you act for. And we'll do that first, and then we'll get people to go through their positions. A brief summary. So many of you already have like a 3 to 5 minute limit. So if you can make it perhaps a 1 to 2 minute, and for the actual parties, if we can try for 3 to 5 minutes for them. So first, name and party, just to give everybody here an idea of who you are, and then we'll go back again to Anthony, and he'll start by saying what his position was.
Do you want me to start?
Yeah, name.
Anthony Damses, on behalf of CFIB, Canadian Federation of Independent Business.
Anna Kadick, also on behalf of CFIB.
I'm John Lawford. I'm Executive Director at the Public Interest Advocacy Center. We're actually a client, and Mosen and Daniel did our argument.
Nidina Stanich, people generally call me LJ because my first name is hard to say, and on for the Canadian Chamber of Commerce.
Jeff Coper, and I was on for TELUS, the appellant. Mosen said it, and as John mentioned, we acted for the Public Interest Advocacy Center, as well as the Consumers Council of Canada.
I'm David Fewer. I'm Director of CIPIC. We're the Technology Law Clinic here at the University of Ottawa. We were one of the interveners. Cynthia and Marina were our counsel, able counsel today.
Daniel Hampson. Me and Mo represented PIAC and CCC.
Cynthia Koo, and as David mentioned, I acted for CIPIC with Marina.
Okay, so where we have multiple people here for the same organization, if we can perhaps have one person summarize that organization's position. So Anthony, though, we'll have you start.
Well, CFIB's interest was really just to get some certainty from the courts. These lower court decisions that were tinkering with subsection 7.5, in our view, were really mucking things up a bit and making it less certain for CFIB in particular to answer a really straightforward question for its members.
If I can interrupt, is everybody here familiar with the appeal, with generally the issues?
Yeah.
Just wanted to be sure, because I realized I totally assumed that and hadn't given any overview of the case. So everybody here knows something about it. Sorry, continue.
Yeah, it was just the basic question of, if we sign these arbitration agreements, are we bound to them? And given how the lower courts had been playing around with 7.5, in our view, not understanding what 7.5 actually meant, the answer was, I don't know. And that's not good for business. And so our position was just to clarify for the court what subsection 7.5 actually meant, and in our view, had absolutely no application in the case.
So what was your view as to what it meant?
Well, what it means is it applies in a very, very narrow set of circumstances. When the disputing parties have a dispute that is covered by the arbitration agreement and is not covered by the arbitration agreement. And then the court gets to exercise its jurisdiction to say, should I separate them or should I merge them? That's it. And so the question of class actions and being able to borrow from some other party's dispute, like the consumers, is nothing to do with 7.5. That at most could come in at subsection 7.2. That was basically our view, which is why in the court today I said, look, this should be off the table. Let's understand what this case is really about. It could be dealt with at 7.2. But it wasn't done that way in all the courts, because the courts have taken a very, and it's understandable. I don't want to understate what the courts have done. It's a tricky issue. What do you do with these non-consumers that look a heck of a lot like a consumer, but without proper legislation to guide you? So that's where the courts started to say, allow their hearts to get involved, maybe over their minds.
Thank you.
I'm going to let Mosen and Daniel talk to the position that we put forth, but I would like, if you don't mind, moderator, to come back to me at the end for some sort of 30,000-foot views from our point of view at the end.
Okay, so that's PIAC's view.
So for the Canadian Chamber of Commerce, it was a very similar view about certainty, but we thought the certainty should definitely land on the arbitration clauses are enforceable for all business parties, and we also went for a sort of reach in our factum. We didn't get to it today in oral argument, but we wanted the court to recognize a new organizing principle, Basson style, of freedom of contract, so viewing all contracts, but especially commercial contracts, through the lens of freedom of contract in construing them, and so giving effect to arbitration clauses in commercial contracts between business parties.
Okay, well, I was on for the appellant, and somebody asked me to win this appeal. So I said in the argument I wasn't agnostic about any of the points, so I wasn't. So what were the points for our clients? So TELUS, of course, in the eyes of many in this context, is wearing a less than white hat because we're trying to exclude 600,000 people from the class who would otherwise, if the court below was upheld, form part of the class and suing in a class proceeding against TELUS. The main challenge that we had, I think, which was used effectively by Peter, was, generations of the Ontario Court of Appeal have read this section in a way that's opposite the way we think it should be read. So you have the initial hurdle of saying the way in which it's been interpreted by, including 5 judge panels of the Court of Appeal, by some of the very best judges in modern Canadian history, they're just wrong and plain wrong. So that's the initial persuasive burden. And of course the secondary burden is how do you try to take something of the black hat off you and to justify what the statute does expressly in a more broader policy world, because I think the Supreme Court of Canada is always interested in whether or not you have a policy foundation as opposed to just a black letter law. So in the first part, it was very interesting because if you read all of the previous decisions, almost nobody actually interpreted the section. So even Griffin, for example, which is a 5-judge panel written by Justice Sharp, who's one of the sharpest judges we've had in the last 30 years, he offers no interpretation of Section 7.5. He basically assumes that the previous interpretations were correct and that there's a power to effectively decide on the court whether to grant a stay or not grant a stay. And if you don't grant a stay, everything goes into the court proceeding. And so in that way, you can actually capture and bring into the class proceeding effectively things that would otherwise be excluded. And so the first part was what we had, I think, going for us, and I think emerged from the debate today, which was very interesting from a black letter lawyer's perspective, is if you read Section 7, it interweaves the directions to the court in a pretty coherent way. So Section 7.1 says, unlike the statute for 90 years, you shall stay a matter if it's been assigned for arbitration. Section 7.2 says you can refuse to stay a proceeding if any of the following conditions exist, and none of those conditions existed in this case. And when you get down to Section 7.5, it then says, in respect of the situation where there are both claims within and outside the arbitration agreement, it says you can stay the proceeding in respect of arbitral claims and continue the proceeding in respect of other matters. And in the Court of Appeal, in our case, Justice Blair said, well, other matters doesn't feel right that you can actually reach out and say that there are other matters in a proceeding when the other matters are other arbitral contracts, which in this case is other cases in which there are commercial agreements which are bound for arbitration. And as everybody knows, the Consumer Protection Act rendered invalid any agreement by a consumer to agree to arbitration at the outset of their contract. And so consumer agreements weren't the subject of Section 7 at all. It's only a question of whether or not there's going to be a stay entered in respect of the business claims which are bound by business arbitration agreements. So when you get to Section 7.5, and I don't think we have Peter here, so I would say the battleground between us was effectively what's the better interpretation of Section 7.5. I said essentially if you read Section 7, you have to read it together. It starts with a mandatory stay. It has express provisions which take away the stay in identified circumstances that allow the court to refuse to stay the proceeding. That's the language used. but that doesn't apply here. And so when you get to 7.5, you have to read words like the agreement, a stay of proceedings, and you have to read them coherently. And essentially, if you read the opening language, what's contemplated is you either can grant a partial stay or not a partial stay. But if you don't grant a partial stay, there's still the absolute right to a stay by business customers under 7.1. So that was my view of it, and I think there are other support because the 7.5 has two conditions. You have to find, in order to grant partial stay, both that there are mixed claims, that's the first part, and secondly, that they can be separated. If they can't be separated, you can't grant the stay. Now, what the Court of Appeal in this case had done was to say, well, actually, Section 7.5 is an extension of the exception found earlier in the section, so that it's another exception to the right to have a mandatory stay. And we said, well, hold a second, there's just no language that connects those two. And on that basis, the Court of Appeal's wrong, and the trial judge said, actually, subsection 5 gives a broad discretion to stay or not stay. And so that's really the centerpiece of the statutory construction argument. The other side argued it is a broad stay because may is a very broad term. It says stay the proceeding. They argued that the stay the proceeding means you can stay it or not stay it, and therefore that's what the Court of Appeal found, and you should uphold the Court of Appeal. And he forcefully said, you know, that's why people, when reading it for 30 years, coming back to certainty, that's actually what the Court of Appeal has been doing for a long time. And so you should uphold that interpretation. So just one more minute, I guess, in terms of trying to develop the policy.
I won't cut you off.
No, go on.
So developing the policy, it's always a challenge when you're acting for a party like TELUS, who's present in physical terms here in Allen.
Careful what you say,
counsel for TELUS. But it's always a challenge when people go, well, hold it a second, as the court did to me. They said, well, let's be real. I mean, no one's going to arbitrate a $100 claim. And so you're really consigning this to oblivion. And so what are the best policy arguments to try to take some of the sting out of those kind of questions? And we knew we'd get those questions. Bob Sharp in the Court of Appeal and Griffin basically excoriated the idea that you would expect any of these cases to go to arbitration. He basically said it's basically sending them into oblivion or sending them into nothing. And so the fundamental policy platform against that is the statutory preference for arbitration and the statutory decision to only set aside the right to arbitration for consumers. So my argument was that there's a real difference between consumers and business people. The business people approach these disputes differently than consumers. It's not a trivial difference, it's not only a deliberate difference, but there's a real difference on the ground. Business people may choose not to take these claims at all. They certainly may not want to be lassoed into a class proceeding with $1 million for consumers. They may choose to renegotiate their contracts. They may choose between providers on the basis of other terms. But they know if they participate in a contract that has a mandatory arbitration provision that they will have to arbitrate. That's part of the bargain that they enter into. So that's the opposing, if you will, policy to the concern about business people being left in the lurch. So I said essentially, you know, business people in this context want to be left in the lurch. They don't want to be lassoed into consumer protections that are passed by the Consumer Protection Act. So the final comment, which I think is really interesting, is the interveners argued that there's a category of business people who are akin to consumers. So there's prosumers, or I forgot the other phrase.
Hybrid.
Hybrid claims.
Don't steal our thunder.
Which are not the same. Exactly.
They're
We'll
gonna
have to
explain
go.
everything.
I'm glad someone's going to tell me what a prosumer is. I love the phrase. It's whenever you can invent a new phrase, that's a good day. So I thought that was interesting because, and I'd be interested in your strategy, because on one hand you might argue actually the interveners are pushing against a pretty heavy tide because they're pointing out that in fact the people they're concerned about are not covered by the exemption of the Consumer Protection Act. So are they speaking via the Supreme Court of Canada to legislative reform? I asked you that question. But it is a two-edged knife because the stronger you point out that there are people who aren't covered by the section, who maybe should be covered by the section, in some ways in an advocacy point of view, you're sort of making my point, which is they're not covered by the section, and therefore the court can't stretch the Section 7.5 to somehow capture them when they're not otherwise captured. So that's there's a bunch of other points. I've got 30 pages of notes.
I'm sure we'll come back to some.
I'll call that a day.
So we don't actually have, if I'm not mistaken, counsel for the respondent amongst
they
us.
apologized last minute, so they couldn't.
Okay, so I do hope that some of the interveners who are not on the side of certainty, including Mohsen, can provide perhaps a little more than my 1 to 2 minutes, but a little more. You can even repeat some of the arguments that were advanced by the respondent. And I do note in passing that Jeff did try to explain what the respondents had argued and did so respectfully.
Sure, it's a variety of arguments they made, but I actually need to, because it is not here to lay out the foundation, because our arguments on behalf of PIAC and CCC follows along the premises that they lay. I'll go back to the first points that were made here, that the word proceeding is just limited to individual party actions, and why are we even talking about class actions? We looked at that and saw no reason why that should be the case. I actually went online and looked at Oxford Dictionary, found the meaning for the word proceeding. It meant a dispute, and in many statutes it's used to refer to both individual party actions, multiple party actions, including class actions. That's why we have a Class Proceedings Act. So that was one issue. We had on our end no doubt that 7.5 properly applies to class proceedings. And then we looked at the two competing interpretations of Section 7.5. The way the Ontario courts have interpreted it, and the great majority of the other appellate courts who actually commented on this, and the way that TELUS was saying it should be interpreted. So the Ontario courts say the discretion to stay refers to the discretion to stay arbitrable claims, those claims that are subject to arbitration. So the motions judge has a discretion to stay them or not to stay them. But the motions judge's discretion does not refer to matters or disputes that are not covered by the arbitration. And that's the usual, the common sense way of how you would view things in the Superior Court. Because if you're in the Superior Court and you have a claim and there's no arbitration agreement, or there's an arbitration agreement which is invalid because the Consumer Protection Act makes it invalid and inapplicable, there is no reason why your claim should be stayed. If it is stayed, what happens to your claim? Do you go to arbitration? No, the arbitrator doesn't have jurisdiction to decide your claim. So your claim just gets stayed and is held in abeyance in a limbo. That doesn't make sense if you practice law. The other arguments, the other interpretation that's been adopted by the Ontario courts is that they have a discretion. The court doesn't touch the matters that are not dealt with that are not dealt with by the arbitration agreement. I'm sorry, it's been a long day. And the court's discretion is to decide if it wants to stay the matters that are subject to arbitration based on an objective inquiry. They look at the circumstances and say, is it reasonable to separate these two matters, which in our submission include claims by different parties in a class action, by staying the arbitrable claims, and then presumably the others continuing in court. So we had that difficulty from the outset with the interpretation that was being proposed. But thinking about it more deeply, and in terms of the class actions, because I'm a class action lawyer, I do plaintiff side class action work, and I do consumer side class action work. What happens, we just thought about it and said, what happens to these consumer class actions if the interpretation that TELUS is proposing here is accepted? We're not talking about a third category. I think the prosumer argument is more within Marina's expertise, and she'll talk about it. But we intentionally coined the term hybrid consumer because we didn't want to limit that group of people who are in the gray area between consumers and non-consumers. We didn't want them to be limited to prosumers because they're not. They include anyone who uses a service or product for both personal and business purposes, and that is everywhere in our society now. Many people have computers here. Most likely, if they work, they use it for their work, also for their personal purposes. They send personal emails. Cell phones. I have one cell phone. I'm a lawyer. I use it for my personal matters, and I also send work email and receive work emails on it. So what happens to these people? We thought about it, and some of these people are ultimately going to be found to be consumers. That is where those people come within the mandate of our clients, and we looked at the competing interpretations and realized one interpretation is going to harm them by always bifurcating the claims and requiring an individual inquiry to decide who is a consumer, who's not. Another interpretation gives the motion judge a discretion to look at the circumstances to see if it's reasonable to separate these matters, considering all the factors, including the importance of arbitration. So that is what we decided to bring to the court, and that was more or less our submission. Not that there is a third category that should be exempted from arbitration, but that the interpretation of 7.5 that was being proposed was one that would ultimately hurt at least some consumers.
Okay, so as mentioned, I was second chair to Marina, acting for CIPIT. We're a public interest clinic, so we took a pretty unabashedly policy-driven approach to our intervention. And our starting point was another Supreme Court case from 2017, Duas and Facebook, where we rooted it very much in Justice Isabella's concurring opinion in that case. And we saw this case as basically a natural extension of Duas. So what happened in Duas was, in broad strokes, this analogous situation. It was Facebook, class action, consumers, but the clause, instead of an arbitration clause, was a forum selection clause. So there, the court struck down the forum selection clause, which would have required people to settle their dispute in California instead of BC, where the case was. But it was only consumers. And Abella's opinion was based on the power differential between the large corporation that was Facebook and the individual consumers, who it wouldn't have been worth it for them or even feasible for each of them to litigate their claims individually. And so we were asking the court to take, I guess, a somewhat more visionary approach that was ultimately still rooted in the provisions of the Arbitration Act. And actually, you mentioned the interveners not on the side of certainty, and I would say that we were advocating for certainty, but in the other direction. So in terms of
I like that spin.
advocating for more certainty for the lower power parties in these transactions. And so in this case, instead of the forum selection clause, you have the arbitration clause. Instead of Facebook, you have TELUS. And instead of consumers, you have, technically, they're not legally defined as consumers now, but they're people that we think of, we call them consumer-like relationships. So some people call them hybrid consumers. We use the term prosumer because that's rooted in other technology law contexts, whether copyright, for example, consumer protection, and that's an amalgam of producer and consumer. So if you're an online artist, for example, you consume art online, but then you might remix it and then produce your own art as well. So these are the people, or another example would be an Uber driver, someone in the gig economy, or you set up a Shopify store. You can set up a business in 5 minutes on your phone. That doesn't mean you have any more legal or commercial sophistication than you did 5 minutes ago before you became the owner of a brand new online store. And so how do we get from Duas to extending these similar protections to people who aren't necessarily legally defined as consumers now? And so for that, we turn to Section 722 of the Arbitration Act, which goes to the validity of the contract. And so in Duas, specifically, Justice Isabella's concurring opinion, she said the contract could be found unenforceable if, based on principles of unconscionability, for example, which in turn is tied to stark power imbalances, specifically in the context of, this is going to be mouthful, non-negotiated standard form contracts. So there's take it or leave it contracts that everyone gets the same one. There's a term of service that nobody reads and you click and you move on. And so we're saying in this case, you could do the exact same thing basically and find that because there's all the same underlying factors are the same, where you have stark power imbalance, you have people with very little legal and commercial sophistication, you have a standard contract that was not able to be negotiated. So substantively, the situation is the same, and so you should be able to use that same 722 provision, find the provision unenforceable. And so that's what we were either inviting the court to do, to take that broader, expansive, more policy-driven point of view, or otherwise invite Parliament to reform the legislation so it did reflect that policy. If I got anything wrong, David's welcome to correct.
No, very good. The only thing I'd add was the phrase access to justice is something that we saw this case very much as an access to justice case. And so we wanted to make sure that the court heard that. I think that message was clear to the court. That phrase was used by the panel well before we took the podium. So whether or not the decision ultimately kind of comes down and reflects that perspective, it's going to have to at least deal with it. How do we ensure that our arbitration schemes actually do provide access to justice for everybody who's going to have consumer-type disputes or even business-to-business disputes under these kinds of standard form contracts? The last point, we see, I mean, the Arbitration Act was 1991 legislation?
91.
91, okay, so it's getting a little long in the tooth. The gig economy was not a thing. The internet was barely a thing. And so, the kind of circumstances that we see happening already now with the Heller decision in the Uber case, that fact scenario was literally impossible when the Arbitration Act was created. And so, we wanted to put in the back of the mind of this court, are they handcuffed by the vision of arbitration enunciated in that legislation back in 1991, or does it have the flexibility within the legislation to infuse its interpretation of the provisions in a way that ensures access to justice for all those who need it?
And just for those who aren't aware, the Heller and Uber case was a class action by Uber drivers where the court said that they would have to individually arbitrate their claims in the Netherlands.
Thank you. So I'm seeing the tension emerge. In terms of the Canadian Federation of Business is talking about a new organizing principle of freedom of contract.
No, that's a Chamber of
that's
Commerce.
Oh, Chamber of Commerce, sorry.
Sorry, guys.
My notes are red. And Jeff is talking about a bargain, and when he used the word bargain, the first thought that came to my mind was, are there any examples of customers of TELUS that were able to bargain their way out of a mandatory arbitration clause, or is this not a contract of adhesion? So when we talk about a bargain, it has a connotation of a give and take, a quid pro quo, and it would appear here to me that it's not really a bargain. It's much more a take it or leave it, and query in this day and age whether it's possible for a business to operate. Because I think of examples like a waiver. I can choose if I want to go ski, I effectively sign a waiver that I'm putting myself at risk. And the court will uphold that as part of my freedom to contract. But here, can a business possibly can a business operate without a cell phone? And I would suggest no. So to the extent that, is this really a bargain? Is this something that is really the product of freedom to contract? And I would direct my question to Jeff, and I apologize to the Canadian Chamber of Commerce.
Okay.
Do you want to take it first?
Sure. I mean, we spend a lot of time around contracts and adhesion, but they're contracts or they're not, frankly. And nobody likes these ticket clauses, contracts that you sign the terms of. But there's a great efficiency in having these kind of contracts. If TELUS, for example, had to send someone to bargain with each individual business over each of its cell phone contracts, your cell phone bill would be, number one, much more expensive, and number two, the whole service would operate differently. So in the consumer context, yes, people need protections. They need all sorts of abilities to get access to justice and to be able to bring their claims. Frankly, in business interactions, you price in the risk. You price in the risk that TELUS is going to overcharge you. Sorry, TELUS. The TELUS is going to overcharge you on a few items. And, maybe at the end of the contract you walk elsewhere, maybe if it's bad enough, you do go to an arbitration. But it's a different calculation. I think it's right to say businesses view these kinds of take it or leave it service contracts differently from consumers, where $100 actually is a big deal. And, you feel like you don't have the resources to deal with the big company, whereas, Walmart or McCarthy Tetro or any other sort of organization that has, you know, power in the market, it's a different calculation. And in general, I worry about this whole, contracts of adhesion, these aren't really contracts. You stop enforcing provisions of those, it's not clear to me where you get. And these, if we're not going to enforce something in a contract of adhesion between business parties, between sophisticated commercial parties, it's not clear to me when we are going to enforce it. And it's not a good thing, I think, to start reopening that and seeing that these aren't contracts outside of the specific case where you need to protect consumers where there is an imbalance of power.
So I would say amen, sister. Amen. But the
Okay.
you got time to respond.
Yeah.
But-
Can I just ask
but-
one
but
question before Professor Pavlovic?
I haven't said
We haven't
my
finished.
extended
I'm so sorry.
amen.
Yes, no, absolutely.
That's okay. But go ahead.
No, go ahead. I
No.
didn't realize. I thought Professor Pavlovic was up.
No.
So
Okay.
yes, Jeff, and then
Do I have a
Anna, and
minute?
then Maria.
Oh, okay,
Yes.
good. No, this is great. But let me just say two things, and I agree that contracts of adhesion are contracts. For the validity of an arbitration agreement, you just need a valid contract. But also, and let me push back on the contracts of adhesion point. How many contracts of adhesion have you entered into in the last couple of days? So every time you buy a Starbucks, every time when you go to buy your shoes and you go in and go, you know, and I know you buy La Boutin, for example, I'm sure that everybody here knows La Boutin, you go in,
I'm based in
La
Ottawa.
Boutin, that's $1,000 a shoe. I'd like to buy it for $820, you know, and you know, those lovely shoes there. And
Not
it's
La
funny
Boutin,
how
for
rarely,
example.
it's funny how rarely they go, oh, you know, we'd like to reconsider our pricing policy now that you've raised that with us, right? So almost all the contracts we do. Now, why do we do that? Because it's efficient. Because we know what they cost and we can make a decision whether or not to buy it. In relation to adhesion contracts, if you don't think Bell and TELUS are at each other's throat in a knife fight for every single contract, they are. And look at their advertising. It is a knife fight sometimes with it's not even polite. But in relation to arbitration clauses, interesting enough, one offers an arbitration clause, the other does not require an arbitration clause. So if you don't like arbitration clauses, then go to Bell. But guess what? Bell's not going to renegotiate the price with you probably unless you're a business, in which case they're going to...
Don't go to Bell.
And the reason people don't go to Bell, because guess what? If you're a business person, the least of your concerns is going to be whether or not you have an arbitration clause in your cell phone contract. Just as in your Starbucks contract. With or without the knife.
I have a ton to say, and then I'm going to flip it to John. Sorry, Anna, I can't really hold it.
Oh, go ahead.
And I think I'll start from the premise that nobody who argues for consumer interest has said that the contracts of adhesions are going to disappear and people are actually going to go and individually negotiate. There is a common understanding there is considerable inefficiency in these contracts. The problem is that because of arbitration clauses or class action waivers or forum selection clauses, there is inability to challenge substantive provisions, and these contracts have grown in scope and have started, give us your firstborn child kind of thing, and there is no ability to actually access courts in order to get interpretation on some of these substantive rights. So they're here to stay, it's obvious, but they have to be scaled a little bit, at least, to figure out how they're going to actually work both for consumers and businesses versus now currently working only for businesses. And on your point on, you can go and choose a different provider who does not have an arbitration clause. Not only that people don't read these contracts, arbitration clause is not going to be what's a deal breaker. It's going to be the price and the term of the contract and how much data you're going to get for your data bucket. There will not be a single consumer who will be able to make an informed decision to say, oh, I don't like arbitration and therefore I'm going to go to an alternative provider.
No, but consumers aren't bound by that, right? Consumers.
Right, but
we never argued.
Okay, but let's put it in a different way. So let's put a different contractual restriction.
Okay.
And let's say we have an issue not with pricing, which would be under Consumer Protection Act. We have an issue with privacy, for example, that is not covered by Consumer Protection Act. And there's no equivalent Ontario legislation to BC legislation. So a consumer class action on privacy would not actually have the protections in Consumer Protection Act, and consumers would be required in Ontario to go and arbitrate. Right? So all
isn't Section 7 and Section 8 of the Consumer Protection Act
For the
invalidate
matters
any
covered by the
arbitration?
Consumer Protection Act. But there are
Well-
consumer matters that are not covered by the Act, and there are a swath of consumer relationships that are not actually in the Act itself. So from, my
So how are
relationship
the
to my
contract
lawyer.
claims? Because the contract claims in this case that consumers had were stayed. Right? We're not allowed to go
because
to
it was
arbitration, they were
because
not
the
stayed
issues of billing were actually covered by the Consumer Protection Act. So all I'm saying is
There's some
your,
other
your argument
categories
that
not covered.
we do
Okay.
consumers have a power and they're going to make
Right.
an informed choice and they're going to choose an alternative provider, and I
No,
won't
was
name
arguing-
names.
Just to be clear, I was arguing for businesses doing
Right,
that.
and
So
so-
consumers, I think, are.
But even for businesses, like
Yeah.
a small business of a 3-person
Right,
basement
right.
startup office won't be able to assess that, and they're going to go with the particular plan that they have. So I think we're talking the same language in terms of these contracts are here to stay, but we need to reframe them in a way that they actually work for everybody, because right now they're not working for everybody. John?
I'll give Dan, and then as long
And,
as I get a chance to say something.
I really have to ask, so of the number of business customers who sought to join this class action, this consumer class action, how many of these customers are what we have been referring to today as hybrids?
We don't know.
This
Because
is,
I don't have that
Well, in a
information.
class action, no one really at this stage
Nobody
moves to join.
there'd be a point I'd like to make, which
Yeah.
didn't come up in the argument, and I don't think came up in the lower court, so you guys would maybe know. But nobody gave any evidence as to whether the folks in the class paid TELUS for enterprise or for a regular phone. So I think that 90 or more % of the people that we're talking about just went into TELUS and paid them their residential for a residential phone. TELUS didn't say, oh no, you're a business customer, pay us the business rate. They don't do that, they sell residential phones. So I was looking for someone, hopefully, to make the argument today, which didn't happen, probably my fault for not telling council, that that if TELUS takes the money and doesn't say, are you a business, they're stuck with it. I'm a consumer until you tell me I'm not.
Well, that would be a way in which you could write a different statute than the current.
You don't need to write a different statute, because the statute says you get, if you're a consumer, you get out of, you get protected because you get out of the class action, you get out of the
No, but
mandatory
the
arbitration.
definition consumer depends on your conduct. So consumer is defined by the Consumer Protection Act, not by the circumstance you've defined, but by your use of, in this context, the cell phone. So you are a consumer if you've used the phone for personal purposes, but you are not a consumer if you've used it for business purposes. And the argument, I actually think it's a very interesting, robust policy discussion about how you divide the benefits of statutory protections. So do you divide them around consumers as we would normally think of them? Do you move it up the grade to say, use a different thing, say anybody who has no more than 5 cell phones, like my children, or do you have to go bigger to big families, or anybody who doesn't have a contract with more than 10? That's another way in which you could do it. But I do think your interesting point about privacy, I'm not sure. I'd have to go back and look at the sections about that. But I really admire the fact that you're saying we accept that adhesion contracts are here to stay. So for a consumer advocacy perspective, I think that's a very good point to start with, which is to say we're trying to make them work for everybody. In the United States, the interesting policy is how do you make arbitration work in a class context? Because I think academically, just looking at the intellectual thing for a moment, you'd say, look, if we want to make arbitrations as effective as class proceedings, why don't we put in enabling legislation which would enable a group of people who have arbitration rights to bring them efficiently so that they could bring 500 or 600, might not be what Ellen is dreaming of at night, but 400,000 people bring an arbitration claim. I mean, we do know, and there are proceedings where people gang together and start a proceeding where they're complaining about a local airport and there's 200 of them that join up, or I've had cases where we had entire neighborhoods who were flooded and everybody signed up, so you have 2 pages of plaintiffs. It's not impossible, and crafting a way in which with appropriate rules could be done in the arbitration is an interesting policy thing, and the States has 2 centers which are trying to do that. So.
But wouldn't you simply advise TELUS to insert a clause that says no joining together with other business customers, and we'd just be back here in 5 years making the same argument. Wouldn't that? That would be what I'd advise TELUS. Put away the phone.
So
And
my
then I'd
question,
say, but we'll be back here in 5 years.
my question was going to be to everybody: is there a place for a more robust version of the doctrine of unconscionability, which I understand is more robust in the U.S., but in Canada is effectively useless on a practical basis? Is anybody
Marina
here?
has a response.
My submissions were basically that this is at most to pick up on, I could tell that Justice Abella wanted to go down that road. So the only opening that I saw, that's why I threw it there, was to say, well, maybe under 7, and I believe that was SIPC's view as well, that under 7, subsection 7(2)(b), where you have, if an agreement is deemed invalid, and that invalid word would open the door to common law views of unconscionability. But, you know, to give TELUS a little bit here, it's a bit unfair, isn't it? I mean, somebody walks in to sign a contract, intends to use it for businesses, but doesn't disclose that. That's one. 2, a individual buys a cell phone, deducts the expenses in their tax forms as a business, but then wants to be as a consumer. So, I mean, I think that's why I was on both sides of it. I was seeing where is that true balance? And unfortunately, 7.5 doesn't help because, you know, with great respect, the word proceeding is obviously court proceeding. It's not an arbitration proceeding. That's, you know, if you read 7.5, that's what it's talking about. Stay, who are they speaking to? A court in the midst of a proceeding. So you stay a court proceeding. Right? And so there's a lot of mischief going on today about that word. But, so it is not as straightforward. Now, I'm sure TELUS could do a little more investigative work at the front end, but is that realistic?
I think they have a duty to now. Otherwise, I get to say I'm a consumer, and you, TELUS, tell me I'm not. You prove it.
Well,
You're just.
if
I
I
want to
could
know
just-
where did you guys get
Can I
the
just
600?
jump in?
Where did you get 600,000 people from? Because I want to know where that number comes from. I think it's. I want to speak. I want to finish. No, I want to finish. I would like to finish what I'm saying. I want to finish. What I'm saying is, where did you get 600,000 from? Is that just a contention of TELUS? Because who has the burden of proof there? Who's going to say that I'm not a consumer? And what is the basis you're going to judge it on?
So
that appears what's going to be ruled.
the premise that you're operating on is faulty. There was evidence before Conway in the record below on the application for a stay with respect to the nature of the contracts and the classification of consumers as business. There were different kinds of contracts used for consumer contracts, for business contracts, and for custom contracts. So there was extensive evidence that identified the custom negotiation of contracts with big business customers, the negotiation and the use of a different form of contract that was more elaborate and more detailed in relation to the nature of the services provided, data services, all kinds of add-ons beyond cellular service, and then consumer contracts. Before Conway, she posed the question, how many consumer contracts are there? How many business contracts are there? We went away. TELUS did that analysis, and that's where it came from. So the idea, the proposition that there wasn't evidence before the court below as to the nature of the underlying contracts and the differences in the contracting practices and the way they were classified between TELUS is just a false premise. So, this is one of the things that happens with the abstraction from the court below through the Court of Appeal to the Supreme Court of Canada. That dimension of the case was not the center on which the appeal turned, but there was plenty of evidence on that in the court below, and that's where that evidence comes from in Conway. She doesn't reflect the procedural history of that. She doesn't reference where that evidence came from, but it is there.
You see, that kind of evidence, I think, is helpful to Justice Conway if the Court of Appeal's interpretation is the law, because she wants to have a look at circumstances, see if it's reasonable to separate the matters under the Court of Appeal's interpretation. So it helps to know if roughly 70% of this class is potentially consumer, 30% of this class is potentially non-consumer. I don't think you're saying that your analysis individually identified was able to actually ascertain who's a business, who's not a business, and a very good question was raised there. Are you going to ask people if they expense their bills? Are you going to ask them what kind of business they used it for? All of it becomes extremely individual and factual and specific to each person. It could vary from one person to another. And we have a very good example of that in the cross-examination of the representative plaintiff, who himself used his phone for hybrid purposes. So I think what happens is that kind of evidence, there's no debate that it's very helpful if you have the law the way the Court of Appeal crafted it. But if you have the law the way TELUS proposed, which always leads to bifurcation and makes it necessary, you can never have these claims together, so it's necessary to figure out who is in the class action, who goes to arbitration, then you probably need to have an individual inquiry to find that out.
Well, every class action that certifies consumer claims, there are class actions that certify just consumer claims. In every one of those cases, it doesn't avoid the question of whether someone's a consumer or business user. You still have to have an individual proceeding. Every one of those cases will contemplate that after the determination of the common issues, who's in and who's out. In other words, who's a consumer and who isn't. That issue isn't avoided by either having just a consumer class or having a hybrid class, because you still have to determine the nature of the relief. Is it a statutory claim? Is it a common law claim? What are the nature of the damages? Because they may differ between statutory and common law claims. Whether you have both or just one, the issue is still present, and the cases all say that's an issue. It's deferred until the individual issue stage of the proceeding. It doesn't disappear. It's there.
So that's the thing. The issue is not present if you can keep all the claims together. So if the non-consumer claims and the consumer claims are in the same class action, that they have the same common issues that decide the circumstances for everyone. No, hold on a second, let me finish that. You don't need to make a decision. Just think about it. You have an order staying claims of non-consumers. These are all TELUS customers. And this is what you were asking for. You went to Just Comedy and say, give us an order, staying all, you call them business and we call them non-consumers. Stay all non-consumer claims, certify a consumer class. We don't take issue with the consumers. Fine. What happens is that in that scenario, you have to have a determination as to who goes to arbitration, who doesn't. It doesn't become so easy as to let's run the class action and then we'll find who's in the class. Because if I, who used his phone for personal purposes, also sent work emails, waits for, well, we've had this class action going on for 10 years now. It's still, people are fighting about certification. Waits for 10, 15 years until after the common issues trial. There's an individual inquiry, and I'm found to be a business. What happens to my claim? Do I go to arbitration 15 years down the road? So you see, it's the confluence of the Arbitration Act, Consumer Protection Act, Class Proceedings Act, make it impractical.
So that's true. What you just said is true. It's the confluence of different statutes. But in the case where it is, unless we succeed in the Supreme Court of Canada, the current case has a common issue, but there are separate issues for consumers within the current case, because the Consumer Protection Act gives some rights to consumers that are not held by non-consumers. So in these cases, and as lawyers, complexity is not always a bad thing, right? So you have something good to fight about. So in this case, though, you can't avoid that distinction unless you're going to give all of the rights to everybody who is a purchaser. Like if you say no purchaser is bound by an arbitration clause, then, and it doesn't matter what kind of, you can be purple and pink and yellow polka dotted, and you still are not bound by an arbitration clause. The risk that runs there is that you're interfering with the entire business community's desire to manage their own contracts. And so the business community, whenever it's heard about this, goes, hold on a second, it's one thing to lasso 1,400,000 consumers and try to advance a particular claim, but don't pluck one claim out of our contract with TELUS and then force us to litigate it with 1.4 million other consumers. We can take care of ourselves, thank you very much. And that may mean, for example, guess what, surprise, surprise, we don't care if they've overcharged us by $12, but they're going to hear about it because we're going to phone them up, and because we're businesses, they're going to adjust our account. So those are, businesses have legitimately different views of the ways to deal with small clip ticket changes. And by the way, they're not different than consumers. It's just that class actions allow you to aggregate them to make them this scary thing, which, as Justice Abella pointed out, virtually never gets to the merits, or almost never gets to the merits. So the access to justice through class proceedings is mostly, in terms of behavior, sociological behavior, not actually the generation of judgments about these things. It's the generation of settlements about these things in a sociological sense. So the justification for class proceedings is much more the behavior modification and deterrence from businesses knowing we may be sued, we may be certified, and then we're going to have to pay something in settlement because there might be a claim against us.
I was just going to say,
Yeah.
doesn't the Class Proceedings Act take care of that by allowing a business corporation, a business to opt out of the class? So if I'm an IBM, I have a very large account with TELUS, and I would prefer not to deal with this little dispute through the class action. I would prefer to go to them and say, let's take another look at our arrangement, and do it that way. That's
Yeah, I guess
that's how they work.
I think, David, that's a very good point, and the question really practically is, and for those of us practicing in the area, and we're in the middle of this experience, when you phone business people up and go, well, the opt-out period lapsed 3 years ago, and they said, I never heard about this thing.
Yeah.
How did I hear about it? Well, it was in page A23 of the Globe and Mail that you were being included. And you go, what do you mean I'm being included? I want to get out. And you go, well, actually, the opt-out period passed 2 years ago. You can't opt out. So opting out and opting in as we gain the experience is less perfect a mechanism than you might think. But I actually think that's an interesting question, because I think one thing that might make it more fair is to say to business people, actually, you're in and you can opt out in a more generous way, for example, and make it easy to opt out. If you could online, using your digitalization, just say, look, if you don't want to participate in class actions of any sort, just click yes. And I think the Chamber of Commerce might say to its members, you know what? If you don't like class actions, just click yes for all class actions in Canada. Let's have some enabling legislation, see how many businesses are there. That might be interesting. But I think there are two different worlds as it relates to disputes. And I think the social utility of marshalling together consumers is just a different beast than the social utility of marshalling together business people. I think, and there really are legitimate differences. They're sheep and goats. You know, they're not all sheep.
Cynthia, did you have something to add?
Sure, a few. I don't know. So much has happened since I first thought. Although my first comment was, it seemed only fair to invite you to the floor as well. So I was wondering if you wanted.
There is a chair.
Yeah.
I'm happy to chip in for Jeff from the bleachers here.
Okay. So it seems that a lot of the argument is just getting tripped up on definitions and labels. So who's a consumer? Who's a business, and we're just talking about if you're a consumer who does this or your business who does that, but they have to map onto something at the end of the day. And so when you're talking about sophisticated businesses with contracts of adhesion, for instance, that's true. Nobody is arguing against adhesion contracts for sophisticated businesses, but we're not talking about sophisticated businesses. We're talking about non-sophisticated people.
Prosumers.
Exactly, who happen to run businesses. And some of your examples.
We want cheap cell phones, by the way. We don't want expensive cell
would
phones.
like cheaper cell phone bills. So, for instance, you name McCarthy Facial. Is McCarthy Facial a small business, for example, or like IBM? Is IBM a small business? Because
McCarthy is massive. It has to be pruned back.
Tentacles are everywhere.
Yeah, its tentacles
Yeah,
are everywhere. It's way too influential.
We're starting to run out a bit of time. I've asked questions, and frankly, we've asked questions of each other, and panelists have asked questions. So, is there anyone from the audience that would like to ask a question? I know our Dean, Adam Dodak, just walked in. Maybe he's interested. Aussi, vous pouvez poser votre question en français, et je ferai de mon mieux de traduire et aviser le panel. Yes.
The definitional thing, I just want to run off of that. That wasn't the argument today, per se, definitional. Maybe that's what will come out of it. It's quite possible. This seems like it started off when I heard your presentation that it was a focus point, but it's turned out to be anything but. Where we had two sides that were basically disagreeing about one thing, but I can see how it's morphing into more. One comment, thank you guys for coming out. I don't think it's fair that you get beat up about numbers and retrying the case here. That's not what that was about. So I hope you don't take offense to that. I'm here as a guest as well. And I think the discussion is great. But really the whole idea about setting up definitions, doesn't that really just go back to the legislature? Is that something the Supreme Court should be doing? I'm delving into policy here, but really, should they be tinkering with legislation at that level of court? Anyone?
Well, I'll take a quick stab at that. I mean, so the court's got an exercise in statutory interpretation in front of it, right? And to let's say reasonable interpretations of the statute have been in front of them, so they've got to choose one or the other, or a third, right? And even if the court were to say the legislation is clear, we're bound by the clear words, the clear intent, the clear meaning of the statute, they can nonetheless engage in a dialogue with Parliament. And that is partly what CIPIC's intervention was about, right? Identifying problems, identifying the passage of time, identifying the influence of technology on the realities of kind of modern economic life, and suggesting there's a problem that this triumvirate of statutes that we've been talking about today don't necessarily come down and solve. If this is all about access to justice, and we've heard today, we heard in the court today.
It's an element, absolutely.
Yeah.
That was being expressed.
Yeah, we heard that
by Justice Abella,
that's
absolutely.
one of the fundamental reasons for the Arbitration Act. Then the job's not quite getting done. And so we would hope, at the very least, that message comes clear, and that there is a parliamentary response, or a legislative response, that does ensure that that all consumers that encounter these kinds of difficulties, and I'd say consumers, but including not small businesses, people who find themselves in a significant power imbalance, facing standard term contracts that are take it or leave it, and they have to take it. You have to take it. You don't have a choice. You need a cell phone. You need a computer. You need internet access. You need to be on a social network.
Point taken. We
So,
want the best people.
but you know what I'd say, just from an advocacy point of view, which is interesting. I mean, first of all, I take your opening comment as a compliment because, of course, from our perspective, we want to define it, and it needs to be defined as a straightforward, narrow question of statutory interpretation, because we're basically fighting against the interpretation which the Ontario courts have taken for the last 20 years, and we want to make it clear why they're wrong, right? So that was my goal as an advocate to start with. As you know, if you look at, everybody beats up legislative draftsmen, and that's sort of something we do regularly. But just let a judge write a statute for a change if you want to know how broad language can be, right? I mean, the legislative draftsmen have to draw distinctions. Ever since Hammurabi, you have to divide, those affected by the law who are not affected by the law. That's just part of the effect of passing a rule, right? And at the most general sense, if you're going to pass a rule that's going to be assessed by somebody else, you're going to enter into the vagaries of language and the uncertainties of language, which, by the way, I don't think we should give up hope with. I think it's like today is totally fine, right? And that doesn't mean we can't come up with a more certain, clear answer to the question. And if you look at the debate today, I mean, I'm sort of startled that somebody would pay me to have this much fun. I was able to say, this is what Section 7.5 says. The other side says, here's what 7.5 says. And you have 9 bright people. By the end of the debate, I think you had a pretty good sense of what the linguistic issue was, what the linguistic issues were, and you could make a pretty informed view of which was the correct interpretation. I mean, I think that's in some ways the glory of the common law. I mean, you just saw what if you don't have fun doing that, then I do something else, play Aussie rules football or something. But I actually think that's a very robust and not just fun, but a thoroughly honest system, and it's inevitable if you have rules. That's mine. Go back to HLA Hart, you have to have rules.
So, sort of picking up on something you had said earlier, Jeff, with something that David has said, that you had asked about some of the interveners or even the respondent, I guess,
Yeah.
effectively trying to seek legislative change, which is in and of itself perhaps an admission that the current statute doesn't do what some of the others are saying. Did that thought cross your mind, David, when you and Marina and Cynthia were developing CIPIC's position?
I would say, they're alternative arguments. That's probably the better way to describe it.
Okay.
That was a good question, though, because it highlights that there's kind of been, I think, 2 tension points of discussion. One is what is possible within the Act and not possible within the Act, and the other, I think, is kind of the standalone merits of contracts of adhesion and these kinds of clauses. And where the two interact is where the case has come up, but the discussion is kind of, so people have been talking about the merits of contracts of adhesion almost independent of the Act, and I think there is some agreement that on the challenges of contracts of adhesion in balanced relationships, that nevertheless might not be captured by the app. So there's two things going on there. And the reason I bring that up is that if we do get to a point where it's shown into Parliament, it's worth noting that this has already been recognized in other contexts and in other jurisdictions. So for example, the Wireless Code of Conduct, which is a consumer protection code for mobile wireless phones in Canada, does include small businesses in it, and it extends consumer protections to small businesses up to a certain threshold. So we already have that in not legislation per se, but in regulation, and that's law. In Australia, they recently extended their consumer protection laws to businesses up to contracts of, I don't know, $500,000 or something like that. And so that goes to what I was saying earlier about definitions. It's not just whether you happen to be labeled consumer or business. They look at the actual substantive facts of your situation. And if your situation fits what the legislation has identified as a situation where access to justice and power balance is a concern, then you attract that protection. So it's kind of substance over form approach.
And I think you're always going to, just to jump on HLA Hart for a bit since we're out of law school, you're always going to hit cases in the penumbra. And there's only the statute.
Someone finally mentions the penumbra.
You're always there's going to be stuff there. And
I love you. I think you're fabulous.
So does everybody. Well, I won't speak for everyone, but you're always going to find cases there. And, the words of the statute, we have a clear disagreement here. It was clearly shown, what do we do with this? We spent a lot of time on definite and indefinite articles today, but the words of the statute will only bear so much. And so if there are these other concerns in the background that are going to hit in penumbral cases, we have prosumers and hybrid consumers and all the other things, it sounds like a job for Queen's Park to go and figure out what they want and what the law should be, because there's only so much we can read in without distorting the text entirely. And I think it was a good narrow focus today, but there are broader concerns, and a lot of them are well placed about how these laws interoperate and what happens at the tough interactions between the various groups and the various legislative provisions and the various interests here. But most of this is a legislature problem and not a court problem. It's not, frankly, something even 9 very intelligent people who read tons of HLA Hart, I'm sure, can solve in this case.
The trouble is, we're going to wait 4 years until we can do anything in the legislature.
Well, I mean, that's another problem. But can I say one thing? In the category of unconscionable, in the category of bad ideas, broadening unconscionability, I think, is a challenging matter, because what you're inviting is the swamping of relatively small disputes into really complicated disputes, and I think that's a bit of an unruly tiger. I think, interestingly enough, I think our culture's changing, and I just say this: there are areas where I think we would say that people's choice should be limited, right? We should limit their choices in their own protection, in areas, but we got to be careful about that. So businesses aren't interested in you limiting their choices for the most part, but if you take a totally different area, for example, the area within which you have the right to change your will at the last moment, for example, is the courts will basically let you change your last will when you've just woken up in the morning and decided the 4 of your children who didn't visit you last week are really no longer in your sort of favorable category, and Alex, who's been paying attention to you on the weekend, gets everything you have.
Unless you're in BC.
Well, that's a complicated area, yeah, unless you're BC. But my point is actually it's an ongoing cultural question as to when do we permit people to make choices or not. For our part, when you're into the business category, businesses want that freedom to choose. And it's really more in the personal category, which really consumers are part of, where you're going to put limits on choice, I think.
Remind me of the question I was going to ask.
I think Anthony was going to ask.
Just especially for those who are not friendly towards adhesion contracts, I wonder what your comment would be if, say, TELUS decided to offer a pick and choose, kind of a menu. And one of those menu items was, I'll give you unlimited data if you agree to arbitrate. If you don't agree to arbitrate, you will pay X amount of data. And so it's no longer a true take it or leave it. It's here, you tell me what you want. Now, I'm sensing what the answer is going to be, but can it be put in a term that's not just about, broad stroke, everyone knows that's wrong? Like, why is it wrong? I would just be curious.
Well, it's going to be a violation of net neutrality and unjust discrimination, which is what I'd say in CRTC, and I would win. And then then we wouldn't have this problem. And I'd just like to say that
How about the price?
We're here today because CRTC didn't resolve this 15 years ago. We told them you shouldn't round up, and they didn't do a damn thing about it. And now here we are, and that's because you've got a market here that's deregulated. This is the kind of crap that happens when you have a deregulated market. These guys swoop in, they do whatever they want, and then you've got to solve it with a class action. Now we've just seen a class action is even the good way to do so. So I'm quite distressed because this really should never have come to court.
But what's the value adjusted price of a cell phone? I mean, I would have thought we're maybe paying 5% of what we would have expected for the same communication capacity 20 years ago. I mean, we complain about the costs, but we've been the beneficiary, and I mean, this is the debate, right? We've been the beneficiary of a massive expansion of our ability to communicate, to manage information. Look at all the computers around, and those computers cost a tiny fraction of what the same computing capacity cost even just 5 years ago or 10 years ago. We've lived through this massive world of change, and mostly that world has been one in which businesses have been allowed to make these kind of choices and impose these kind of contracts, and they've driven huge efficiencies. So I think it's it's not absolutely black and white to say, well, we shouldn't let businesses do this, because the overall effect in our lifetimes has been very beneficial to consumers, very beneficial to all of us, I would say. I remember saying no one would ever, I had a colleague who went to Motorola when he had the 4-pound phone, and I said, look, no one's ever going to buy a phone to carry around with them. I already have 3 landlines, why would you want another one? So don't take investment advice from me, but I would say that that's been largely seen as beneficial by people.
I think we had a question over here.
I think it was this side of the room where I heard someone speak about class arbitration a little while ago, or the concept
Yes,
of
I
class
did, yeah.
arbitration. This is something that was discussed in court too. How would that achieve the aim of behavior modification? Because of the private element, you're taking away any of that, like, public shaming. Sorry, TELUS, but like you're taking away that element. So how are you leading to behavior modification?
Well, I think it's in development, right? And I think it depends on the rules. So arbitration doesn't have to be confidential. It can be public. It can be binding on others. It depends on the rule and the structure within which. So JAMS in California, which is a very technology-oriented structure, has a class arbitration system. And I'm not completely familiar with it, but it isn't the case that it has to be confidential and it isn't binding on other circumstances. I can tell you, though, if you're running a business, and you have, let's say you have a class arbitration where you have 50,000 people and you've just been found by a qualified arbitration panel to have overcharged them. That isn't not only is it not a good day for Alan Dabb when he gets that message, but it's not a good day for the president of the company. I mean, they don't take those reversals and go, oh, well, let's just move on and do nothing. It does achieve a substantial behavior modification for businesses when they find out that they have been found to breach their agreements. Small claims, by the way. You know, small claims aren't binding on anybody. I mean, you talk to the CEO of a company, whether if he's found to have, by a provincial court judge in Pouce-Coupé, British Columbia, to have overcharged his customer that he pays, he hears about it. Even though it's not binding, it isn't scalable and otherwise. But it's a determination of fault that people pay attention to.
I'm curious what CIPIC's position is. If this wasn't TELUS, let's say this was a small business that wrote up this adhesion contract and had another small business sign it, would the position change?
Like McCarthy's.
Like a very small business like McCarthy's.
If it was one small business and another small business?
Sure, and then the other small business wasn't happy about the adhesion contract or the arbitration agreement. They said, we actually want to hop on to the consumer consumer class action. Would that change your view?
I don't think it would, because you still have the considerations of access to justice, right? So is the aggrieved party in a position to actually get a remedy?
Even absent the unconscionability concern in 7.2?
Even absent the, I mean, because what if the arbitration agreement says you have to go to The Hague? You have to go to The Hague, and it's going to cost you, $15,000 to show up. You got to do it in Dutch, So it's a question of do you have access to justice, or is access being barred?
So it's going to be on a case-by-case, every arbitration agreement we're going to have to examine, is it The Hague, can the parties afford The Hague?
Yeah, I mean, I'm going to be afraid of you when you're in private practice, because, I mean, one of the strategies of it, I mean, I'm not pointing any fingers at anybody in the room, one of the strategies of the use of arbitration clauses and class action waivers and whatnot, is to make it more difficult to hold that company to account, well, what we've been calling, access to justice, to obtain access to justice.
Well, in Ottawa, we have,
The DRC.
that's right, and they have an arbitration center for where, people pay $500 to get access to arbitration. They just don't really want to go to court.
Yeah.
And that's their actual access to justice. So they want arbitration above court, and it costs them arguably less. So I'm not sure that it's always the case that arbitration is, used as something to shirk your.
Oh, I would never say that it's always.
By way of
Certainly
timelines, because the access to justice starts with when are you going to get the answer, right? And my colleague to my right said, well, we can wait 4 or 5 years for new legislation, but you can wait 4 or 5 years for a class action to get finally resolved. Depending on which arbitration rules you can get an answer in 90 days. And it's just like small claims procedures. So there are clear significant advantages to arbitrations for people who have a cause they care about. Your point about The Hague, I think, is well taken, and I would say this, and that is you're looking from a sociological fact, are there contracting practices out there which primarily have as the goal putting up obstacles? Absolutely. Absolutely, there's not much argument to the contrary. I don't think that's what's done here, but if you say you have to go to The Hague, and you have to fly first class and buy me a ticket as well, and that's where Justice Abella was talking about the vindication of rights limitation principle, and I think to the extent that that's where contracting practices are going, you're inviting legislative intervention in those things. By the way, forum clauses are all about us, right? It's all about the court system when you do a forum clause. So it is in our home court, and I think we have much more legitimate right to say, no, we're not going to let you do that in relation to the choice of court proceedings as opposed to arbitration.
I think when you're talking about arbitration as well, one thing that Justice Sharp brought up, I believe, in the Griffin case, and it was quoted by the majority in Seidel, was another consideration when you have, on the one hand, a number of small litigants, low-value claims, and on the other hand, an established party like TELUS. That's just an example, but any big company that has a lot of leverage. Is there a concern that the arbitrator may not, with all due respect to arbitrators, may not be as impartial because they may want that repeat business of the big company, but they don't really have that much of an incentive to favor consumer type claimants? That was a concern that Justice Sharp raised, and I mean that's another thing to have in mind when you're thinking about arbitration. We've been praising arbitration so much, we've heard a lot of praise, we heard a lot of it in court today, and we read a lot of it in the factums of the appellant and some of the interveners. But I mean, these are some added considerations.
I'm sorry, may I just, since I've been involved in about 80 arbitrations as both counsel and arbitrator, and I've trained some of our retired judges to become arbitrators in Canada, I don't think it's fair to assume that arbitrators are inherently biased for the parties that are appointing them, and I'll tell you why. Because it's as somebody who's been on a 3-person tribunal, the moment you get even the stench, the light whiff that one of the arbitrators is partial, that individual's opinion is discarded. And the 3-person tribunal becomes a 2-person tribunal because we know what that other arbitrator is going to say. And most arbitrators are not going to risk their reputation for one case.
Yeah,
so I don't think it's
the
realistic.
notion wasn't inherently that they're biased. And you say, yeah, I agree with you. Most of them are not going to do it. But you're not going to have 3-panel arbitrations for these low-value claims. And on the one hand, I mean, it's a consideration to have that in mind. You'll have a big company with a lot of repeat business, and on the other hand, you have someone who has a $100 claim, $500 claim, comes and goes, never comes back to you, never brings you any more business. Well, another consideration to have in mind.
I'm sorry, but I mean, we have to talk about rules. We know that there are for example, just as one, the IBA guidelines that have a very clear rule that if the same party has appointed you more than 3 times within 3 years, you are not allowed to take the appointment. So unless you're making a heck of a lot of money once a year from a case, again, this concern is not there, and I've heard these arguments, and I mean, if they were true, I'd be more than happy to support them. The only place I've ever seen them true, and those institutions no longer exist, are for very small institutions that were particular to a trade industry where the members were required to arbitrate, and that issue did come up. And guess what happened to those institutions? they went away because they lost their credibility, which is why the big institutions like ICC, and believe me, I'm no lover of the ICC, but the ICC, the ICDR, the AAA, these centers actually stay afloat because there is some belief in the system. So, I mean, but I do know where you're coming from, but I think it's, you know.
Okay, it's 5:20, so we absolutely have to be out by the latest at 5:25. Quickly, is anybody feeling so bold on our panelists to offer a prediction after the hearing today of where the court's going to rule?
There's certainly
Tell us.
someone's going to win or lose. That's my same cell phone prediction.
Well, okay, so I'm gonna throw it out there. With the new Supreme Court under the new chief, we have been seeing judgments with 3, 4, or 5 different opinions. So and in those circumstances, is a win really a win when you have 3 different opinions on a particular point and then 2 more on the other one? So I'm less inclined to actually see it as a win-lose. I think everybody will get probably a little bit, and it won't get any clearer than what we've had so far. That's sort of where I'm kind of going.
I'm feeling bold. It has to be TELUS. The question of joining a class action is not the other matter. You cannot consider these to be the matters in Section 7.5. Section 7.5 has nothing to do with this. And for the sake of arbitration and contracts and preventing future parties contracting with parties like TELUS from just hopping onto other people's class actions, it has to be TELUS. That's how I feel.
No, thank you.
I felt very strongly about this.
All right, I think we've got to wrap it up. I want to thank everybody for being here. I want to thank actually the individuals from TELUS too for participating in the debate in a sort of consumer protection friendly environment. So we really appreciate you guys giving us that perspective and some information perhaps about the record that we didn't have. So thank you.
Thank you. That was fun.
Thank you.